Justice Thomas has our opinion today in Case 15-1485, District of Columbia versus Wesby, and he's going to announce it himself.
This case comes to us on a writ of certiorari to the United States Court of Appeals for the District of Columbia Circuit. In 2008, D.C. police responded to a late-night complaint about loud music and illegal activities in a vacant house. Inside, they found utter bacchanalia. Strippers were giving lap dances in the living room. A naked woman and several men were in the bedroom with a bare mattress and open condoms. The house was largely unfurnished. Cups of alcohol were on the floor, and the officers smelled marijuana. Many partygoers scattered when they saw the uniformed officers, and some hid. The officers questioned everyone and got inconsistent stories. Two of the strippers said that the tenant, known only as Peaches, had given them permission to host a bachelor party in the house, but Peaches was nowhere to be found. When the officers eventually spoke to Peaches by phone, she was nervous, agitated, and evasive. She hung up on them several times. At first, Peaches claimed that she was renting the house and had given the partygoers permission to have the party, but she eventually admitted that that was a lie. The true owner confirmed that he had not given anyone permission to be there. The officer then arrested the partygoers for unlawful entry. The charges were eventually dropped. Several of the partygoers sued for false arrest. The district court concluded that the officers lacked probable cause to arrest the partygoers for unlawful entry. It also determined that two of the officers were not entitled to qualified immunity. A divided panel of the D.C. Circuit affirmed. In an opinion filed with the clerk today, we reverse. We hold that the officers had probable cause to arrest the partygoers. Considering the totality of the circumstances, the officers made an entirely reasonable inference that the partygoers knew they did not have permission to be in the house. Because most homeowners do not live in barren houses where they invite people to have sex and do drugs, the officers could infer that the partygoers knew the party was not authorized. The officers also could infer that the partygoers knew they were not supposed to be in the house because they scattered and hid when the officers arrived. The partygoers' vague and implausible answers to the officers' questions suggested that they were lying and that their lies suggested a guilty mind. And Peach's lying and evasive behavior gave the officers reason to discredit everything she said. In concluding that the officers lacked probable cause, the D.C. Circuit made two basic errors. First, it viewed each fact in isolation instead of as part of a totality. Second, it dismissed any fact that the partygoers could explain away, even though probable cause does not require officers to fully rule out a suspect's innocent explanations. We also hold that the officers were entitled to qualified immunity. Under this court's precedents, officers are immune unless the unlawfulness of their conduct was clearly established. Given the legal landscape at the time, reasonable officers could have concluded that the law permitted the arrest here. There was no controlling case holding that a bona fide belief of a right to enter defeats probable cause, that officers cannot infer a guilty state of mind based on conduct alone, or that officers must accept a suspect's innocent explanation at face value. For these reasons and others set forth in our opinion, we reverse the judgment of the D.C. Circuit. Justices Ginsburg and Sotomayer have each filed an opinion concurring in part and concurring in the judgment.